I'm Jeff Mitchell. I'm here with Kallen Heenan. We're both lawyers at Nova Injury Law. Today we're here to talk about a great new case out of the Nova Scotia Supreme Court. It's Riley Peterson against Ashton Anderson and Sydney Kenney. What's fascinating about this case, it's really one of those that you'd expect to come across in law school. It's about a party that went absolutely wrong. It's a classic case of students drinking, what to do, good choices and bad choices, and it all ends in disarray. Our client, Riley Peterson, was a house guest, a co-tenant of one of those classic homes near campus. We're talking Dalhousie University in Halifax. He wasn't part of the party because he wasn't a varsity athlete. He's not invited. He's studious. He's got an exam the next day. He's studying, not drinking, not at the party. Everything goes to mayhem, and all of a sudden he finds himself injured when he's trying to restore order and ultimately just trying not to get hurt. And this case is all about how the law treats this mayhem situation that maybe we've all been around in the past, maybe when we were in university.
So this case was, from a legal perspective, about what extent the courts and really society are going to impose liability on the host of a party for the actions of someone else at the party. And not only the actions, but the intentional actions. In this case, our client was a tenant of the host of a party. He was in his room trying to study. He wasn't drinking, wasn't playing along. And he comes out into absolute mayhem in a house party. There's a fight, multiple people involved. There's an intoxicated host, and ultimately our client is assaulted. It was our position that not only is the party who assaulted our client responsible for the harm that was caused, our position was that the host of the party actively contributed to the state of the party, to the party getting out of hand, and that this is what, in effect, caused or was a cause of the assault.
Yeah, so when we think about how this all started, we have Riley who's seeking a lawyer because he's hurt, because he did nothing wrong. It's the classic story. You didn't expect to be injured. It's not your fault, and now you need help. You're wondering what the law can do for you. And so we end up having a conversation and talking through who would be liable for this situation. And that's really the first question. Who is it? Obviously, he was injured by someone, the person that applied force to him, who assaulted him. Obviously, that person should have responsibility. But is there a second party? Is the host of the party that let this situation become chaos? Are they liable? What does the law say about that? And that got us into a conversation about what the state of the law was and what the Supreme Court of Canada has previously considered in this realm. What we quickly discovered is there's really no case like this one before. We're talking social host liability, that's the legal concept, applied to student housing. So, Kallen, why don't you tell us about social host liability? What are we even talking about here?
Yeah, so that's a legal term, but in essence what it means is the party or person who hosts the event or gathering responsible for things that happen at or after the gathering. So common circumstances that this might apply to are the classic: someone gets hammered at the party and then they drive home and then they, hit someone else or cause damage to others in the vehicle. Who is responsible for that? So the obvious answer is the person who got behind the wheel. And that is generally true, but it's not the only answer to the question. The law can hold multiple people responsible for any one event. So the question went from there to, does the host of the party have any responsibility?
And going back to your comment, so if I'm hosting that Christmas party and there's people drinking, am I responsible as host to take everyone's keys and, put them in a basket? Am I responsible for making sure no one takes their keys? Do I have to arrange taxis or Ubers or taxi chits for everyone? How far does this go? How much do I have to be parent for everyone at the party? And at some point, adults are adults. They're responsible for their own actions. But obviously, in our case, and just like the one where someone's hurt by a drunk driver, that injury victim is looking around and saying, who can I recover from? Ultimately, a personal injury claim is about getting paid for what your injuries are. And if somebody's insured, like a homeowner, there's a source of compensation if you can find negligence against them.
It's a fine line here between what a court will and will not hold the host responsible for. And there are even different standards for different hosts. So a commercial host, if you own a bar and you're inviting people onto your premise to drink, to party, well, guess what? You have an elevated duty as opposed to someone who's just having some friends over for a gathering. Say there's parents who are allowing their 16-year-old children to host a party, knowing that there's going to be underage drinking and yet doing nothing for it. Or say they even gave alcohol themselves and provided the alcohol. That is going to be a different analysis. What we wanted to determine at the end of the day is, where do the courts draw the line here in Nova Scotia? So we have law set by the Supreme Court of Canada that sets kind of the general guidelines, but each case is fact specific and each province has its own unique case law. So what we wanted to determine here is how far that line goes in Nova Scotia.
Yeah, the key words here is something more. And when we think about what the Supreme Court was looking at in that case that really set the bar, they're talking about some additive element, this something more. And we said, heck, we know what happened to Riley. We know the situation. Seems like there's that something more element. We've got a jammed house BYOB event. It's just fuel on a fire, something that's inevitably going to erupt, and poor person who's not even involved ends up getting the sharp end of the stick. And so we think to ourselves, okay, we get it. In a bar context, there's bouncers. It's a commercial environment. In the house party where parents are facilitating drinking, they get it. There's something more there if something goes awry. Is the Nova Scotia Supreme Court going to say this chaos circumstance at the varsity party, is it so bad that it has that extra ingredient where our client will be able to have recovery against the homeowner? And of course, you can expect what the other side says. This is a floodgates argument, meaning if you let him win, then who's next? How do you prevent every single host out there from the birthday party, the Christmas party? What about the book club? How far does this go? Does this mean you can't have fun anymore? You can't have people over your house? That's the concern. And so how do you distinguish this party from a pretty tame book club on a Thursday night that happens to go wrong, but really you could never predict it?
And it's important to note this was the first of its kind in Nova Scotia. So there was no fact situation in Nova Scotia like this. So this was an entirely new case on new facts without a leading precedent or a leading case that the judge from Nova Scotia that the judge could use to decide the case.
This case, because it went to trial, it didn't settle. Trials happen when cases can't settle. There's no resolution between the parties, and a trial occurs. We're here representing Riley, and there's a lawyer on for the host, and the party that assaulted our client doesn't have a lawyer at trial. So we call these self-represented litigants. So all of a sudden we're down at trial, and we have a self-represented litigant making opening arguments, doing examinations and cross-examinations without being a lawyer. It was really impressive, very hard experience, and you could see that this defendant was getting better as they acclimated to the process and were involved in the process. And I'll give a shout out to the courts here too, because we always try to make sure every litigant has an equal opportunity, and when a party doesn't have a lawyer, there's really an extra obligation on all of us to make sure that someone without that lawyer can participate and it's fair for everyone. So, credit to all involved to make sure that everyone understood and we went at a pace and a level of understanding so that everyone had a fair shot. This is a judge-alone trial, so ultimately the judge was hearing all of the evidence, and it was one person that was going to make that decision as opposed to a jury trial, which we rarely see in Nova Scotia. So as the trial unfolds, it's the plaintiff that presents their case first. And uniquely, what we decided to do for strategy reasons is call the defendants as part of our case. It allowed us to question them and kind of set the tone with our own case theory early on. Once we called them, we have to layer in with our own witnesses to support the case. We called the plaintiff, so Riley gave a whole bunch of evidence. And it was tough because we had to walk him through that whole night, what his expectation was before, all the background planning for the party, and ultimately what happens to him, how he ends up coming out of his room and what he saw, seeing the fighting below, how people moved around the house. And this happened years ago. So he has to relive this moment and ultimately carry through saying how he ended up getting kicked down a flight of stairs, tumbling down, and ending up at the bottom of the stairs injured. It's not nice to go through, especially we've known Riley for years. It's not a great feeling leading him through remembering his own injuries, but we have to do that to establish what actually happened and present that information to the judge. But there were other people around too. There were roommates as well who have recollections of certain parts of the night. And really, I think for us, our case was a bit of a puzzle. How do we put these pieces together in a way that's clear? Not everyone's memory was perfect. It was a party. And not everyone was around for the whole party. And so it's how do we put these pieces together to make an arc of a storyline that's all true, it's all evidence, and have the maximum persuasive value for Riley. So we do our case, and then obviously it's over to the next parties.
So there were two defendants here who took diverging approaches. Ashton Anderson, the party who assaulted Mr. Peterson, his defense was one of self-defense. So it took two primary elements. The first element was that he felt threatened by Mr. Peterson and alleged that Mr. Peterson, in his words, charged up the stairs towards him in a threatening manner. To support this, he used his own evidence and also called as a witness his friend on the hockey team who was with him at the time. The second part of his defense was to do with the kick itself. His evidence was that his foot was stationary and that it was not a kick, but at best a light push. So these two elements combined were what he used to make up his argument of self-defense. The defense counsel for Sidney Kenney, who was the host of the party, had a different approach and what I'd say as a much more legalistic argument and position. So their position fundamentally was that the law should be very hesitant to put liability on one party for the intentional acts of another party. As Jeff talked about earlier, this is the situation, the analogy of, the library or a friendly gathering. It's really an argument about when does it stop. If we're going to impose liability on the host of a Dal varsity party, then there could be liability on anyone.
Yeah, and ultimately, adults are adults. We choose what we want to do, and how can one host be responsible for adults adulting, even if they are drinking.
And to support this, the defense focused on framing the party as being nothing out of the ordinary. So a question the defense kept asking their witnesses, which was made up of generally of friends and ex-teammates of the defendant Sidney Kenney, was this varsity party anything out of the ordinary? Was, before the fighting, were there confrontations? Were there loud noises? And generally the evidence that they got was that this was a quote-unquote normal party and that there really wasn't an element of unusualness to the party, or it wasn't more out of control than any parties in years past.
Yeah, that something more ingredient really wasn't there. There was no obvious marker in the history and no significant event during the course of the party before Riley was injured that it would obviously have to be shut down, or, there was a clear chaos moment and that it was allowed to continue on throughout the night.
Our approach to these arguments was to focus specifically on the facts of where the host was that night, what was she doing, what ultimately happened, but also what did she not do and what did she fail to do. At law, you can not only be responsible for for actions you take and overt things that you do, but also for things you don't do or things you fail to do. And so that was a really kind of key part of our theory against Miss Kenney.
Yeah, and it was important that we stack up all these factors because at the end of the day, we're trying to make this look as poor as possible, really, in terms of what the host actually did, and say, listen, there are plenty of diligent, mature, responsible hosts out there. It was possible to run a safe party, but in this way, through how you organized it, it was poor, and obviously this was a recipe for disaster. Ultimately, we know the outcome here. The judge found that there wasn't that something more. There wasn't enough for her to find liability against the social host. So the conclusion is our client was, was successful for the assault portion of the case. He was assaulted, but we weren't successful against the defendant host. And ultimately, that something more, that situation where we could ground liability against the host, that's for something else in the future and not on these facts. And so I think one of the big reflections for us is, what is that? I mean, I've been doing this for a while now, and I've never come across a case that was this egregious in a social host context. Again, things happen in bars. There's bouncers, but this is something different. How many people do you have to stuff into a house before it's just negligent? How drunk does somebody need to be before they can't actually host? These are still unresolved questions, but it's obvious, it's hugely factual. That specific party will never happen again. So what is it?
Yeah.
And the challenging part of this is people are getting hurt at these events. There are negligent events, and the injuries can be very, very severe, from people going downstairs to decks collapsing to fires happening with no safe escape. I mean, it's serious. And we don't know when it will be enough. And the problem is these people, these injury victims, need legal help. And now there's another precedent that gives concern to personal injury lawyers when they're looking at this. Is there really that something more aspect? They're going to look at this case and say, well, geez, we didn't win against the host in the Peterson case. Let's assess this new person against that case, and really, do they have a chance of success? At the end of the day, we don't restore health in our cases. We can only get compensation for someone, compensate them for their injuries. And a question is there actually a pot of money for the person to recover from? And often we find that someone who assaults somebody doesn't have money to satisfy a judgment. You can win all the money in the world. If there's no one to pay you, it's not worth anything. And that's why in these social host cases, plaintiff counsel is looking to ground liability against that host because they're insured.
To piggyback on what Jeff said about where the courts will draw the line, it appears that either an intentional act on behalf of the host, so something like forcing all the party goers to do shots, providing enormous amounts of alcohol, hazing, that will be required to ground liability, or behavior that is so reckless that it's on the border of intentional. There appears to be great hesitancy from the court to ground liability against a host for the intentional acts of others, where the host was what we would consider negligent but not in a willful or, extraordinarily reckless manner. So it appears that that's something more from a factual perspective would be actually encouraging the, unrestricted alcohol use, encouraging the fighting, starting the fighting, setting up the fighting, intentionally not calling the police. It seems like that line is pretty high, but may arise in the future.
Yeah, that's right. So for Riley, what's next? Well, he has a damages claim to run. It's amazing that we are in trial for the better part of 2 weeks and the case still isn't over. So the trial and liability is concluded. Riley was successful against one party. Now we actually have to prove the case. We have to prove the damages. And so we're going to have to marshal a lot of evidence. And this is every personal injury case. We have to look at our client and say, what were the injuries caused by that assault? And then look at medical records and expert evidence. And ultimately, we're going to be running another trial, unless we can settle, to see what the case is actually worth. And ultimately, a judge will make a decision and grant an order, if we're successful, that allows compensation for Mr. Peterson. I think there's a couple messages that you can take from this case. Certainly, one of them should not be that you can just get assaulted and no one's responsible for it. That's not the message. You can pursue these defendants, and you should. Ultimately, civil law is about recovering compensation when it's deserved. And you shouldn't be turned off from pursuing a claim just because it's hard. Different lawyers have different strategies and different risk tolerances for the cases that they'll take. And so it's always important for anyone looking for a lawyer that they consider their options, speak to multiple lawyers, and ultimately figure out one that they have a great fit with. Because what we've learned is it's a long process, especially in this type of case. This is not a get rear-ended in a car accident, easier situation. Like, this is going to be a hard case, and it's important that you have a great relationship with your lawyer. I think another message here is responsibility still matters. Clearly, some defendant at some point is going to be on the wrong end of a decision because they hosted a party that's out of control. A defendant, your party, your hosting, doesn't need to be the next standard case, the case that the whole legal profession knows about. So it's important that you're diligent, that you're thinking about plans, that you're not encouraging terrible, risky behavior. And then I think there's another aspect, which is how these events come together. Often a party is planned around an event or a purpose or a group, and liability can fall on the organization from which these people come.
That's a great point. And in this specific case, the party was specifically for Dalhousie varsity athletes. So that's a very specific group of people we're talking about here. Now, the school of Dalhousie itself was not implicated in this case. This was an off-campus party organized not through Dalhousie, but through the student athletes themselves. But the message to Dalhousie and universities in Canada in general is clear, and has been for years, that you need to act proactively. You can't just let these things happen. You have to monitor and even go as far as train students, student athletes, and members of your community against risk-taking behavior and against creating the type of situations in which assaults happen, in which people get too intoxicated, and in which people get injured. We've seen this with hazing, and a Dal varsity party that gets out of control is in the same boat. This is something that universities and institutions generally need to look to protect themselves from and to just stop in general.
Yeah, and in the educational context, sure, this has nothing to do with Math 1000. This is not an academic course, but the reality is they're students, and the institution should be involved, and the responsibility, we would say, goes further. You have to teach great academics, but you also have to teach young adults to be responsible, especially if they're going to walk around with the logo of your university on it. It's just a matter of time before it's a hockey team or a club or something else that goes wrong, and some defendant who didn't think about it, ends up injuring a plaintiff who had nothing to do with it, and finds themselves looking for a personal injury lawyer to help them recover for injuries that could be really serious. That does it for our discussion today about a new case, and I hope this has been interesting. Hopefully it's resonated with you for some aspect of it. Maybe you've been at a similar party, or maybe you're thinking about how the law is developing around these types of incidents. Anyways, I hope you found this interesting. Kallen is a fabulous lawyer at the firm and is always motivated to think about the deep issues on cases that are more complex. And I hope you find that you should contact us if you have any questions about a legal situation. We're always here to answer questions. And if we can help you, we certainly will.